Ready? Start. In the facts and circumstances of this case, the High Court interfered with the pure findings of fact even after the amendment of Section 100 CPC in 1976. Stop. The High Court would not have been justified in interfering with the concurrent findings of fact in this case even prior to the amendment of Section 100 CPC. Stop. The judgment of the High Court is clearly against the provisions of Section 100 and in no uncertain terms clearly violates the legislative intention. Stop. In view of the clear legislative mandate crystallized by a series of judgments of the Privy Council and this court ranging from 1890 to 2006, the High Court in law could not have interfered with pure findings of facts arrived at by the courts below. Stop. Consequently, the impugned judgment is set aside and this appeal is allowed with costs. Stop. Para. The apex court observed that it is well settled that even if the first appellate court commits an error in recording a finding of fact, that itself will not be ground for the High Court to upset the same. Stop. Again, in Harjeet Singh versus Amrik Singh within bracket 2005 12 SCC 270, the apex court with anguish has mentioned that the High Court has no jurisdiction to interfere with the findings of fact arrived at by the first appellate court. Stop. Controversial issues involved in the present case are relating to question of fact and there is concurrent finding of fact by both the courts below which cannot be interfered with by this court. Stop. No substantial question of law is involved in this second appeal and the same is dismissed. Stop. Stay application filed therewith is also dismissed. Stop. The suit for injunction filed by Rajkumar and his brother against Muhammad was collusive one. Stop. The said suit was decided in compromise and now other legal heirs of and Abdul were impleaded as parties. Stop. It was pursuant to that collusive suit that the defendant appellants wanted to dispossess the plaintiff respondents from the room which is part of undivided property by getting its northern wall demolished, which is in occupation of the plaintiff respondents. Stop. Initially, the plaintiff respondents filed objections under Order 21 Rule 97 of the CPC, but on being so advised, they later sought to withdraw the objection and filed regular civil suit which cannot be said to be barred by law. Stop. Over.